Okay, it looks like we are live here on our happy half hour Carolina Retirement Planners happy half hour here on the 13th of August. In the doldrums of August, it has certainly felt like summer these past few weeks.
Yeah, it's been very hot.
If you've just tuned in, this is sort of the pregame show. We start a minute or two early because of the way the delays work, and we wait till the clock ticks over, and the clock has ticked over, so it was officially 4:30. Welcome everyone. Cheers. I'm David Shakavich. I am the president of Carolina Retirement Planners, and with me is my daughter and partner Sam Shakavich.
Hello.
And we have again today a special guest, attorney Dick Horgan. Hello, Dick.
Hey, Dick.
Hello there.
And what's everybody drinking today? What do you have, Sam? You know?
Well, last week I felt so bad because it was National IPA Day. My husband's a professional brewer, and I was drinking white wine. So today I'm drinking a Waterline IPA for him, for you, boo.
Okay. And how about you, Dick?
A scotch and water today.
Scotch and water. And I normally have, although it doesn't look like it, I promise you this is herbal tea, but I will make up for it later. So,
Dick, this is a good day to be drinking scotch.
Yeah, it's been raining here quite a bit.
Yeah, I don't know how it is for everybody else, what it's like over in Brunswick County and Leland, but we have just been storming. My poor dog has been clinging to my side.
a lot of areas had thunderstorms move through last night that were really pretty intense.
And also just a reminder that we're so happy that you're joining us, but because of the way this works, we can't tell that you're here unless you comment below. So say hi, tell us you're here, tell us what you're drinking, what the weather's like near you. I see that we have Miranda, Teresa, and Sylvia with us. So welcome, ladies.
Good to see you, so to speak, here on our
yes. And so whenever you comment, we have Amy there is our moderator who's going to be typing in your Facebook comments, and she's going to pass on the comments or questions that you make so we get a chance to see them. And Bob and Val are here. Hey, y'all.
Good to have you with us. One other thing I'll mention, and I'll mention it again in a couple minutes. On Facebook down below, it'll say, I think it says share. And if you click there, it'll actually have a little option for a watch party. And if you click that, it'll tell your friends that you're watching this and give them a chance to join in. And then you can actually chat back and forth with them too if they appear. But your comments will disappear from our screen so you can talk about us. But but say hi before you do that. But a watch party is nice because you can kind of just let people know we're here, and they may enjoy it as well. So
yeah, and so one of the incentives to start a watch party is to be entered into our happy half hour drawing. So each week we raffle off 2 bottles of wine. Last week, Ed and Renee were the winner, and they had submitted questions every week since the beginning. And I have my hat fully prepared for us today. So there are a few ways to enter. You can email us at any time during the week with a question about the topic we're going to be talking about or a potential future topic. So if you send us an email, you'll be entered. If you refer somebody to us, if you say, hey, tell them to come to our happy half hour, we'll put you in the hat. And if you start a watch party, we'll put you in the hat. Pretty much we just want to give you guys some wine, and I think it's worked out very well so far.
And let's see, Robert, I think we got Bob and Val. Cindy has joined us. Hey, Cindy. James.
Cindy is real hot.
Rick, I see Rick. Hans, James, again, another 2 James. Yeah, same James. And Jim is here.
Dan and Barb and Dan and Lois.
And oh, yeah, the bar, yeah, so it's good to.
And Pat and Dave. So welcome, y'all. We're so glad to see y'all. But I think it's a good time to get kicked off, don't you, Dad? I know that this has been a really excellent topic. We got a lot of really good feedback from the happy half hour last week. And so we decided to bring Dick back and really have a chance to dig into your questions. And we've been getting a lot of them. So we've put together the ones that we've gotten throughout the week, and we're going to try to just cover as much as possible.
And then we have an extra special offer at the end, so you want to stick around for that.
Other than the wine giveaway.
Yeah, once again, say hi, and if you want to click share and watch party, you'll share us with your friends. But we were so popular and had so much last week that people had so many questions. We thought we'd bring Dick back for a second time, and he's going to answer specific questions for us here in this half hour. Sam, what is the first question we have queued up for Dick?
All right, so I got this question in from a handful of people, and people want to understand the basics. So Kay and Robert essentially wanted to know, why have a trust instead of a will or a simple will? What's the difference between the two, and why would you choose one over the other?
Okay, great question. It does come up all the time. And when I meet with a prospective client or an actual client, we wind up talking 10 minutes about this. But today I have to keep it somewhat short. Remember, the definition of a will is a ticket to probate. And a will only applies to the assets that fall under the jurisdiction, if you will, of the will. And so any assets governed by a will are going to go through the process known as probate, with the expense, red tape, and delay inherent in that process.
So a will always goes through probate, right?
I beg your pardon?
A will always go through probate.
Yes, great thought. The only way, Sam, a will is given effect is if it's presented to the probate clerk. Someone shows up, puts their hand on the Bible, says, I'll be the executor, I'll administer it.
Mm-hmm.
So by contrast, the assets that are placed in a trust, as opposed to a will pass under the terms of the trust outside of the probate process and just avoid it entirely. And the choice between a will and a trust comes down to whether, largely whether you want to do any one of the following three things. Number one, do you want to save your family the money and expense and delay of probate? Number two, do you want to have any say? Do you care what your beneficiary does when they get their inheritance? Do you want to restrict or control what they do? Can't do that by joint with survivorship. Can't do that by beneficiary designations. So if you want to avoid probate and have some control over that 17-year-old or that 31-year-old who spends the money too fast, then the trust will do it as opposed to the will. If the other thing is, in my mind, it's every bit as important as restricting your clients. Let's say your kids. Let's say you're blessed with sensible, level-headed adult kids. You still may want to protect them with their inheritance from divorce, creditors, and estate tax. That's what a trust can do for you. So the choice between a will and a trust really depends upon what you want to do in the way of keeping it out of probate or restricting or protecting your family.
And Dick, isn't it, if you have a will, isn't like a copy of the will, the inventory, your assets, everything also in public domain now? It's all at the courthouse for anyone to see?
Yes, one of the minor benefits, the main one is probate avoidance, is privacy. Wills become public and all the details are in the public record and available to anyone who wants to go there and look at it, and trusts remain private. That's one of the benefits of a trust.
One other thing, Dick, if you're moving papers, they seem to be scraping your laptop and it comes across in the sound very loud. So just a thought I'd mention as we're figuring out this Zoom thing. Well, Sam, what's the next question?
Okay, the next question, I got this in a few different ways, but essentially this is David's question. When is a good time to review your estate plan? Or what types of events should trigger you to review your estate plan?
Another good question. There are probably 4 types of events that are going to happen in the real world that might suggest you should review your estate plan. First is your finances. If they go up or down significantly, you might want to rethink your provisions. Number two, and I hate to say this, but a life-threatening, a really serious illness or the onset of a disability for one of your your spouse, God forbid, or one of your beneficiaries. Next would be any major change in your own opinions of your family members. All of a sudden that son-in-law is drinking too much. Forget this happy hour, but you get the drift. And then finally, and the one that doesn't happen as often as the first three, is if there's a major change in the tax laws. That could cause a review. A couple of quick examples. I just mentioned all of a sudden you find out that the son-in-law is not as good a guy as you thought he was, and you had him to be the trustee of the grandchild trust if you lost your daughter. Or if you've got a child, God forbid, diagnosed with Lyme disease or perhaps some other difficult situation. Or, and this comes up regrettably, my clients are not all youngsters, if your spouse is starting to have significant memory problems, you might want to be more protective of your spouse and revise things. So it changes in the real world, finances, health, your opinion of one of your beneficiaries. They start to rob banks, you probably want to do something different. So those are the types of things. But most of the time we don't win the lottery, so we don't worry about a huge increase in our wealth. There might be, God forbid, a decrease.
Mm-hmm.
Okay, and we've had some pretty big tax changes this past year too. So.
Oh yeah, we'll address one of those coming up.
Okay, so what's next, Sam? What's the next question?
All right, so question number 3. This has been a huge question that we've gotten from many people, from Dawn, Kim, Susan, Jim, Wendy, Kathleen. Essentially, if I relocate to another state, will my will or trust still be valid, or do I need to redo it?
That's one I hear all the time. That's a very common question. And especially here where so many people, many of you on this call came from another state, had wills done in another state, and you're wondering, what does it all mean?
Well, the answer is pretty simple. 50 years ago, if we go back in time, North Carolina would not honor a will or a healthcare power of attorney done in Vermont or Alaska. Today they will. So the short answer today is your documents will be honored. They'll be valid. They'll be legally binding here, whether they were done in North Carolina or Arizona or wherever. Having said that, in all 50 states, all the lawyers agree that there are 2 documents that are so state specific, it makes sense if you move to Florida to do the new Florida documents. And that's the healthcare power of attorney and living will. And the easiest way to remember that is, think of the poor nurse sitting in New Hanover Regional Medical Center. She can't be expected to know the language used by 49 other states. We don't say persistent vegetative state. We don't say coma. The other states use a lot of things that we don't use down here. So the documents will be valid, but on those 2, healthcare and living will, you don't have to, but it's desirable to do the local ones. So if you move to another state, those are the ones. Now, your will, your trust, your health, your financial power of attorney and the like, they're all going to be perfectly valid. The only little detail you might change on a trust is, let's say you go to Florida. Well, your document's going to say it's governed by North Carolina law. So if a real problem were to occur, some Florida lawyer might have to pick up the phone and talk to a North Carolina lawyer. So sometimes the only change you might make, rarely though, is it necessary, but you might just say a 1-page amendment. We'll talk about how to do that in a bit. That just says, from now on out, let's have Florida law, because I just moved here, interpret the will instead of Florida.
Now, I have heard that if you come with an out-of-state will, the lawyer here might have to go back and have it researched to be sure it was valid in the state it was written in at the time.
David, that is absolutely correct. You get an A on your part of the bar exam. The legal theory is that for North Carolina to honor it, it needs to have been validly done in the state where it was done under the law in effect at that time. So you get a Pennsylvania will done in 1990. In theory, the person here has to say, what was the law? Did it require 3 witnesses? I only see 2. You know, so that's the theory. But in practice, there are two witnesses and a notary. It's going to be admitted.
But don't they ever, isn't there a chance they may have, you'll end up spending extra money while they research
Oh.
that or have that research?
Oh yeah, you know,
Yes.
that's correct.
See, people don't realize this. You get your, you know, you have your will from out of state, you die, and now the lawyer you go to calls up a lawyer in Pennsylvania and hires him to research that, and you're paying for your lawyer and the lawyer in Pennsylvania. And boy, they're all charging $250 an hour, and it's like a gravy train. Yeah, it's valid, but you're getting sucked up in this.
Yeah.
How about the witnesses, self-proving affidavits? If you don't have self-proving affidavits, what might happen?
Then oftentimes the clerk will have to track down the witnesses and the lawyer who prepared it.
And that's all at an extra bill. And I say,
that's right.
it is, I often tell folks, from what I've seen, it is the legal profession loves to suck the money out of you when you die. You want to get it done correctly in this state and have all the T's crossed, because it will pay off handsomely in the long run. Yes. So next question, Sam. Next question.
Clear caching.
Dick, your face while he said that was priceless. Okay. Question 4. Lisa wanted to know, what types of estate planning documents does a typical person or married couple need?
Okay, this is real easy, guys. If we stick to the basics, I'll add some bells and whistles in one moment. If we stick to the basics, here they are. There are 4 or 5 documents. A healthcare power of attorney, where you say in advance who will make a healthcare decision for you if you can't. Number 2, a living will. That's the pull the plug document, where you state what your wishes are as to whether you would want your life prolonged by artificial heroic means if you're really in bad shape, like permanently unconscious or in a coma. Third would be a financial power of attorney. God forbid someone has a stroke. The wife cannot manage or make decisions about the IRA. The beneficiary designation, who will name the wife, will kick in when hubby dies, but not if he has a stroke.
In fact, this is a key one that people miss. If you're married and you haven't given, say, let's just say I didn't have the documents and I went into a coma, or, you know,
or a bad car accident,
I've got an IRA. My wife wants to manage this IRA. The market's crap. She can't tell them what to do. And she has to go to the court and petition the court to be appointed my
guardian,
power of attorney over me, my guardian. And then doesn't she have to go back and report every year what she's doing to be sure? So it's like, you don't think just because you're married, you know, the court doesn't know, the law doesn't know that my wife and I have been getting along. That makes we hate each other. So I have to give her permission ahead of time. So even as married couples, if you don't have those documents in place, it can be a mess.
You're up the creek.
It can be a mess. You want to get it right. I'll tell you, you know, I've just seen some over the years. Dick and I have been working together now for almost 20 years. And over the years, I've stumbled across so much, it just amazes me.
David, you look about the same. I'm afraid I've aged a bit more. Maybe I won't say it's dealing with clients. I
wish I looked thinner, but that's probably not true either, you know?
Okay, so document number 4 is obviously the will. Who's going to get your stuff, and who do you want to put when you die, and who do you want to put in charge? And then finally, the 5th one that 95% of my clients have is a trust designed to avoid probate, known as a revocable living trust, to save the expense and hassle and delay. So those are the 4 or 5 basic documents. Here are 3 more that are very often used. Anyone with a minor child should have a document that says who they want to be the guardian in case the parents die. That's pretty basic. But a lot of my clients with 35-year-old adult children that just had twins don't have that, the kids don't have that. Second is if you have a good size IRA or 401k, and if you want to protect your beneficiaries, divorce, creditors, and estate tax, you might have an IRA trust. And finally, half my clients want to be organ donors. And there's a document where you can fine tune your wishes. And actually there's one more. It's sad, but I will have clients who have a severely disabled or handicapped child or grandchild. and then enter stage left, the special needs trust. But the basic ones, healthcare, living will, financial power of attorney, and a will, or to avoid probate, a trust. And that's true in any state.
Before we go to the next, I just want to say hi to some more folks. I think we got Dan. Tallulah is here. Tallulah is
Oh,
here, and
We missed Ruth Ann and Mike.
Ruth
and
Ann
Martha.
Mike. Okay. Yeah, I not go up far enough. Okay.
You can go up quite far enough.
Okay, we've
Hey,
got
guys, I got you.
we got Brad and Matt and some guy named Neil. I wonder who that is, you know?
I guess my hubby got off work a little earlier than he thought.
So good to see you all. So what's the next question?
Okay. So this one's big is because a lot of people have questions about IRA trusts in general, but we've been getting some specific questions in from Cindy, from Pat, from Jeff. They're saying, how does the Secure Act affect an existing IRA trust? As you know, we've had some changes in the tax laws, and the stretch IRA is no longer a thing.
Well, it remains a thing for the spouse and for the original account owner. What's changed is what happens to the beneficiary. So the best way to answer the question of how does the Secure Act impact an existing IRA trust is to contrast the prior law, 2019 and earlier, with today's law. Before we got blessed with the Secure Act, when an adult child inherited an IRA, they also, like the spouse, could stretch it out. So if your adult child is 50 when they get half of your IRA, the IRS says they're going to live to 96, that's 46 more years, they would be allowed to take out 146, 145th, and get 144th each year, a declining balance, and stretch it out over 4 decades. Under the Secure Act, it's now has to be all taken out in 10 years by the 10th anniversary. That's not to say it has to be 1/10, 1/9, 1/8. Just that by the 10th anniversary of the owner's death, the adult child has to take it all out within 10 years. Now, with an IRA trust, that just means that the darn IRS gets their tax revenue. It comes out of the IRA and into the trust. The client can still say, oh, no, I don't want my kid to buy the Ferrari or lease the BMW. We're going to have the trust impose some sensible restrictions if the client wants that. So just because the IRS says we want our tax money now doesn't mean that the client has to let the adult child take it out. You can impose restrictions if you want. And there are two, real quick, there are two classic situations, typical situations where the money might be left in the IRA trust. One is, of course, if the beneficiary is going through a divorce or is getting hounded with student loans or has credit problems. They'll just leave it in until it's safe to take out. And the other one is, if the, where are we here? If the client has specified that they want to have installments payable to the young child because they made some poor decisions along the way. But the Secure Act, there are other changes. You know, I'm still working, as you can see, well beyond 70. But I'm now allowed to pay into an IRA. Couldn't do that before. And you have to start minimum required distributions at 72, not the old 70 and a half. Mm-hmm. But those are the main things. Any specific questions people have, just email me. Dave will give you the email later.
Okay, excellent. And so I think we have time for one, maybe two more questions, but what is the best way to make changes to a trust once it is in force? We get this question a lot. I think that Beverly and Chet were some of our most recent ones asking this question.
This is real simple. Let me do it fast. The trusts are under the law of contracts and trusts, not a statute of wills or healthcare statute that requires a notary and 2 witnesses or attorney involvement. So you can amend your trust with only a writing signed and dated by the 2 of you if you're a married couple, or by the survivor of you. Just a writing signed and dated. So here's a quick example. Today, you're Presbyterians, you're leaving $1,000 to your church. You get mad at the pastor that comes in 10 years from now, you want to go across the street to the Lutheran church. You just sit down with a pen. This is amendment number 1 to our trust dated such and such. On page 13, delete the Presbyterian Church entirely or replace it with the Lutheran Church, and let's raise it from 1,000 to 1,500 because my IRA has been going up. Okay, real simple to do. Sign it and date it, put it with both originals of your trust. So there's no requirement of witnesses and notaries. My recent trusts say that, and since 2005, the new statute in North Carolina lets you amend the trust with just a writing, as long as it's clear. And so it should say, this is an amendment, not a letter to my brother that I'm thinking about doing this. This is an amendment to my trust. Sign it and date it, and it's done. Don't mark it up in the margin, because you then start to make a mess out of things. You really do.
So leave the document, leave the original document alone, just add to it and make sure you both sign and date it.
And it is better to have it in your handwriting than to type it out and just sign it. Because now we have 2/3 of a page in your handwriting. If there are any questions, we can really prove that you did it.
Oh, absolutely.
Yeah, I always liked trusts because they were much easier to change. I know lots of people, they have a will, and to make a simple change, you got to find a lawyer and pay him to do it and get a codicil and get it notarized, and nobody ever does it. So, and let's see, also in the back of your trust, Dick, you have like a list of, if someone wants to give some jewelry or their fishing rod or their shotgun to somebody different, it's very easy to do as well.
Yeah, it's really the ladies who care about their jewelry, David. Who's going to get that particular sapphire ring? There's an easy place to list that, what I call gifts of sentimental value. It's usually Schedule B as in boy to my trust. Description of item, who you want to get it, and you sign it, and you can change it anytime you want, cross it out, initial and date it. Easy to do.
So that's, again, it makes the trust much more dynamic. How are we doing, Sam? We're almost at 5. Should we?
Yeah, I think that it's probably time for our drawing.
We have a drawing and then another offer to get more questions answered.
Okay.
So
Well, do you want to go the other offer first? Or do you want to do the drawing first?
let's do the drawing first. Let's do
Okay.
the drawing first.
I get so excited about this. I sit here and I'm writing up all my little names on the piece of paper.
While you're pulling that up, let me see who else is here. We had, we left off with some guy named Neil. Some lady named Sandy joined. I wonder who she is.
Hi, Mom.
Yeah, we've got Kim, we've got Galen and Jeff.
Jeff.
So I'm glad you're all enjoying this this here. Martha has also come in, so it's good to see and hear
All
from
right,
you
so
all.
I'm going to go ahead and do this drawing. And just by the way, if you submitted a question for Dick last week that we didn't get to, I left your name in the hat. I'm not going to do this in the future, so make sure you keep sending them in. But this week I gave you a pass.
You're tough, Sam. You're tough.
All right, so last week was Ed and Renee, and this week is Nadine. Nadine, I think, is one who's been with us pretty much every week as well. So congratulations, Nadine, if you're here, and we look forward to sending you wine.
We will send you wine. Now, first, normally, and we've mentioned this before, some of you may have estates you want to have looked at and get an idea. If you call our office or email us, Susan can set up a Zoom meeting with Dick to look at your things specifically. But Dick has also offered, because we got so many questions that have come in from so many people. Dick, what are you doing next? Or what's the?
Okay, our time is limited. So here's what I thought we could do. At 5:15 today, 15 minutes from now, I will do a Zoom conference for anyone who would like to. I already have from David's staff the email addresses of the people who by mid-afternoon today had asked questions that we couldn't get to. So I'll send out an email, and then it will be a link for a Zoom thing. All you gotta do is click on it, and I'll march through those dozen questions. And I'm told that someone has been taking additional questions while we've been talking, and I'll get those also. But if any of you have a question you'd like to ask, I'll be happy to do it. You might have to wait your turn because I've got a dozen of them to do, but maybe some of the other answers would be helpful. So at 5:15 today, I will have the email addresses of anyone with an unanswered question, and I'll do an email to each of you. If you click on it, we'll have a Zoom with 18 people on it, whatever. And I'll answer the questions and we can stay on as long as it needs because I've got a full bottle of scotch here.
Yeah.
Okay. And so
Oh,
there's some
and
more
also,
ways.
if any of you have more questions, if you'd like to have a review of your estate planning or talk to somebody about it more in depth, call our office, call Susan, and we can set you up with a Zoom with Dick to kind of.
Or alternately, if it's just a little question here or there, you can simply email me at dick@dickhorgan.com and I'll respond.
Yep.
The legal and the financial are like this, and that's one reason we are so glad to have Dick helping us as really part of our team, because we want to make sure that's done right, and then all the paperwork is put together with the two, which is really one of the hard parts and one of the parts that often never gets done. Sam, have we decided what we're doing next week? Did we pick a topic?
I'm on Bald Head Island all of next week, so I ain't gonna be here.
Okay.
I don't know what we picked for next week.
Then we picked the two brothers.
Yes. Why don't you tell us, Dad? You tell us what we picked.
I think we're going to do one of my one of the things is, will I run out of money, and what is it that makes me run out of money? One of the things is what the market does close to your retirement. If the market falls, what it can mean. And in my classes, I've often taught an example. It's one everybody remembers. It's the two brothers example. And it's also, by the way, I didn't mention it yet, at a website called rogo.com, rogo.com. I'm putting up my classes piece by piece in little bite-sized chunks. Go there, poke around, look at the stuff, pass it on to friends. We're going to even revamp it and probably make it even better as time goes on. But I think next week I'm going to go over it here live with you. And it is one of those really pieces that you don't want to miss. You want to invite your friends to. It's one of the most important lessons in how do you manage money in retirement and why is it different. So we will do that. I think we're going to do that next Thursday, 4:30 right here.
And Dick, thank you so much for joining us 2 weeks in a row, for taking the time out of your day. We really appreciate it. This has been really informative. We've been getting a ton of great comments from people about how appreciative they are, and we're appreciative. And thank you all out there in the Facebook world for joining us every week. Some of you are here every week, and we really appreciate it. We really want this to be something valuable for you.
If you missed one of the earlier ones, you can always go back and watch it. They're all there on our Facebook page. Be sure to like our Facebook page, Carolina Retirement Planners on Facebook. And it's fun. We've been enjoying this. This has been fun. Cheers, everybody. And
Cheers.
We will see you all next week.
See you next Thursday.
Thank you.